All rise. Veuillez vous lever.
Noon.
Please be seated.
Okay. The appearances as usual, I presume. And the appeals chamber will now hear defense submissions replying to the prosecution's response.
Madam Presiding Judge, Your Honours, the appellant's reply to the prosecution's response will be dealt with as follows. Mr. Ivitich will address grounds 5 and 3. I will address grounds 1, 2, 4, and 9. I will then conclude the appeal on behalf of Mr. Mladić. I now defer to Mr. Ivitich.
Thank you, Your Honours. I again make reference to my objection and reservation of rights from yesterday. My reply today is likewise limited in scope and subject to the same, due to the inability to meaningfully prepare with my client and take instruction from him as to these matters due to his diminished capacity. I will not address all of the arguments and refer you to our detailed appeal brief and reply for the remainder. I will start with Srebrenica. As to Srebrenica, the prosecution has resorted to merely reciting the precise trial chamber findings that we have claimed are results of error and subject to our appeal. Thus, they cannot act to prevent our meritorious appeal. Prosecution counsel selectively cited and miscited to the facts, some of which are crucial and which I will raise. Again, I stress, we do not deny that others, like Momir Nikolic, and rogue elements of the parallel security professional chain of command engaged in crimes. But they do not have anything to do with Mr. Mladić. I will only highlight certain key positions and evaluate them to the extent possible. Today we heard from the prosecution that the trial chamber convincingly concluded that Mr. Mladić was in command and control of coordinated actions of police and VRS units during Krivaja 95. I must correct the record here, as a plethora of evidence disregarded by both the chamber and prosecution shows that this is not the case. General Krstić of the Drina Corps was in command and control of this operation. I cite Momir Nikolic, transcript page 31355. Richard Butler, transcript T16206. RM 322. General Kovac, transcript page 41392 to 3. General Skrbich, P 14020. And two reports by General Krstić, D 288 and 289. These are just some examples. There's more, but I must move on to save time. The prosecutor today again relied on erroneous trial judgment paragraphs and repeated its claim that Mr. Mladić was in charge of the busing of civilians from Potocari. The prosecution position at trial, in its own documents and through its own witnesses, was that Momir Nikolic was in charge of this. CP 1145, page 45 to 49, and prosecution witness RM 264 at P 1446, page 1 to 15. I would be remiss if I did not note that Ms. Baig attempted to rely on a statement of Mr. Mladić before the alleged existence of the JCE to genocide, given to TV by Mr. Mladić. That is precisely the type of error we have pointed to yesterday. Bravado on TV is not akin to acts on the ground. And the language in the orders that Directive 1, Krivaja 95, and Stupenica as to JEPA, D 290, plainly state that the troops are to adhere to the law. Let me read you the JEPA order. Quote, the civilian Muslim population and UNPROFOR are not targets of our operations. Collect them together and keep them under guard, but crush and destroy armed Muslim groups. That's not a crime. I think we have rather clearly, articulately already referred in detail to the Fontana meetings, and that the acts and language that were there were consistent with legitimate military goals aimed at the armed 28th Division still on the loose in the area. The prosecutor, in multiple occasions today, spoke about this column of men, and each time claimed that it was a crime to blockade and engage in combat with this armed formation. This is contrary to their own expert, Richard Butler, who we cited to many times yesterday. Transcript page 16653. The prosecution are already abandoning ship and distancing themselves from the position of Chief Srebrenica Prosecutor Peter McCloskey at transcript page 486 about the legitimate nature of Krivaja 95. We urge you to read the orders in question, not be swayed by the prosecution scrambling for a new or better argument. By the way, today it was said that the prosecution never said there was a meeting to determine the JCE to commit genocide. That too is running away from their earlier position, set forth in their response at paragraph 226 and 229, citing to the judgment in paragraphs 4926, 4952 to 4958, 5096 to 5088, 5129 to 5131. These judgment paragraphs are precisely where Jonas Nielsen's comments come into play, because the judgment erroneously concluded a meeting did take place and that genocide came from there. And if I were a prosecutor, I would run too from such a position after hearing the embarrassing admission of Mr. Nielsen of the paucity and lack of evidence that the trial chamber erroneously relied upon. And by the way, Prosecutor McCloskey at transcript page 44552 to 3 went into great detail talking about this meeting that the prosecution now is running from in his closing arguments. And its cited in their final trial brief at paragraph 1063 and at paragraph 1105. How many times are they allowed to change their position as to this meeting that from Mr. Nielsen we now see they don't know if it ever happened? The prosecution cannot run from their case, which has been relied upon erroneously to evade a meritorious appeal. By the way, the use of the Nielsen video, as I said, is in relation to the paragraphs I've just cited. It's also consistent with the past practice of the tribunal when tribunal officials speak in public about their prior cases. I point to the Prejudice appeals hearing of 30 October 2012, wherein a video of Chief Prosecutor Bromertz was used in a similar vein. Transcript page 79 to 80 of that hearing. The prosecution tried to infer Mr. Mladić's intent, criminal conduct they called it, from evacuations in 1993, albeit beyond the temporal scope. But let's look at what this criminal conduct was. In 1993, Stoltenberg, again, not Mr. Mladić, but someone with the UN, asked Karadzic if the Bosnian Serb side would agree to evacuate Srebrenica civilians to Tuzla. P7359. Karadzic issued an order for the VRS to provide protection to civilians. D2036. Mr. Mladić enabled, again, the United Nations to send empty trucks to Srebrenica and offered buses. And he opened the corridor to allow civilians to cross into Serb-held territory. That's at P2469. Let's recall the witness, Dr. Simo Bilbija, who personally helped as to this evacuation alongside the United Nations at transcript page 29031 to 29034, who said he was personally asked by Mr. Mladić, which was unique, to assist. And his answer was, quote, General Mladić sometimes, rarely, was in a position to issue orders to me directly as to our work. He never missed the opportunity to underline the following to us: that we should strictly behave in accordance with the rules of our profession, and that we should take good care, if it has to do with the wounded of the other side or civilians, etc., persons of a different religion, and so on, that no one should feel that they have not been given full treatment or full attention. Question. And lastly, doctor, this medevac operation from Srebrenica in April of 1993, approximately how many persons were evacuated in the course of the operation? Answer. The evacuation took place with 2 helicopters. A large number of people boarded these helicopters. We knew that exactly then. I don't know exactly, but I think 20 people could be taken in a single helicopter. They took these people to Tuzla, and during that time, we would be waiting there, and during the day, I think there would be 4 trips. He testified Armia BIH wounded soldiers were also evacuated. So again, the prosecutor would have us believe that a UN-led evacuation is criminal conduct by Mr. Mladić. But let's return to the 1995 evacuation. The prosecution chose to run from our actual arguments to embrace the errored analysis of this under the laws of military necessity. That is not what our argument was. The UN established that the sanitary and other situations in Potocari and the heat and the number of people created a potential humanitarian nightmare. Mr. Boring, Colonel Boring from Dutchbat, transcript page 10075 to 10076. And did you see the population was willingly boarding the buses that, due to the situation and the dire straits which they were in, wanted to board the buses as soon as possible? Did you observe that as well? Answer. What I observed was that it was very hot at that point, and a large group of people had not had anything to eat or drink for quite a while. They were in a hopeless situation, and the buses were a way of being able to depart. So a group of people wanted to leave by bus, hoping to be taken to a better place. Question: will you agree with me? The number of population, including women, children, and elderly, constituted a humanitarian risk due to the conditions that surrounded them, should they have stayed there any day longer? Answer: yes, that was the problem. He then went on to confirm that nobody in the local commune was in a position to provide enough medical or food care. Van Doon, transcript page 10380. I will only read the bolded section. This is his testimony. There was no other solution there than to evacuate them, because, like I said before, there was a big possibility that epidemics would break out. People had no food, no water, and the temperature was very high. So from that moment on, there was no other solution. That's correct. General Nikolai at transcript page 10652 to 10653, and also it's the same as P1165, paragraph 59. Again, I will only read the bolded part on the next page. Directly after we stopped the air attacks, we realized that the civilian population would have to be evacuated from Srebrenica. There was no food, enough medical care, or even protection from the weather for the people there. We had hoped to do this under the cover of the UNPROFOR troops and even use UNPROFOR trucks if necessary. I will stop right there. So, per the prosecution's position, these acts considered by the UN are a crime. Surely that's not true. Going on further, transcript page 10654, this is still General Nikolai. And I will start again with the answer, which is bolded. Answer. Yes, we didn't need General Mladić's advice to be able to conclude that the situation of the refugees in these circumstances was an untenable one. This is what the prosecution wants to call criminal conduct. Then so be it. The UN is guilty of criminal conduct. It's an illogical conclusion. Today, they tried to link Mr. Mladić's subordinates from the Drina Corps and Zvornik Brigade, but this is not in accord with the prosecution's own forensic evidence, particularly Dean Manning, transcript page 14205. First of all, am I correct that as part of the Office of Prosecutor Investigations, you had occasion to seize a certain number of weapons from the VRS barracks of the Prejudice and Zvornik brigades to test fire them so as to see if they could be linked to any of the bullet casings found at the various execution and burial sites? Answer, that's correct. Transcript page 14206 to 14207. Again, for brevity, I will only read the answer, which is highlighted in part of Mr. Manning again. Answer, Your Honors. I agree with that statement, and we are discussing the same matter. To my knowledge, the test firing produced many hundreds of shell casings. They were examined, and the results were negative. End quote. And I just want to add that the forensic expert of the prosecution, Mr. Curtis, confirmed these results. I'd like to move on to Kravica. The prosecutor today several times implied that the coordinated killings began on 11 July 1995, while Mr. Mladić was still in Srebrenica. This is also false. The prosecution chief of investigations, Aaron Gallagher, testified that prior to Kravica, there were no such coordinated killings. And this is at, I will read her testimony from the transcript at pages T 12245 to 12246. In terms of the investigation that you've been involved in, and your colleagues have been involved in, is there any concrete information as to whether or not the burned hands incident, I'll call it, occurred immediately prior to the executions or during the course of the executions that happened on the 13th? Do you have any concrete information either way? Answer. No. There's many statements out there regarding that incident of the burned hands happened early on. There are some that say it precipitated. Some that, yes, the executions had started, the shooting had started already. And when I mean, I think it was early in the course of the execution or at the beginning, but I don't mean to say it's at the end.
David, could you kindly pause till we reestablish connection? Thank you. Madam Presiding Judge, we are ready to recommence. Thank you.
Thank you.
As I was saying,
Mr. Ibe,
yes,
you may continue.
thank you, Your Honor. As I was saying, this is again still the testimony of Aaron Gallagher. But it's clear it happened sometime early on. But I don't know if it was immediately, if it was right before or right at the beginning of when it started. There's many different statements. And then at transcript page 12242, question. And was it part of your investigation that prior to the incident where the individual tried to overpower and take the gun from this person, that no one had been shot at this location? Answer. There was not a mass execution prior to this execution, not that I'm aware of. Her colleague, OTP investigator Blaszczyk, confirmed there were no killings at Kravica warehouse until the incident when a Muslim grabbed the gun of a guard. So let's talk about Kravica and what happened. And let's keep in mind it was the MUP at Kravica. And what was this burned hands incident? Indeed, Nejo Jovicic, the driver for the MUP commander, confirmed that the MUP were solely at Kravica. That's at transcript page 33742-3. Gajic testified that he learned of an incident at Kravica. That's T30319. Expert Butler stated he is unaware of any VRS personnel at Kravica at the time of the killings. That's T16622. Even prosecution eyewitnesses presented evidence that can lead to a reasonable conclusion that there were no prior orders to kill anyone at Kravica. RM274, a survivor of the incident, described how water was being provided to those detained at Sandici Meadow to cool down. That is at P3098, page 4. I'll skip ahead a bit to the next paragraph. As further indication of no prior intent for foul play, RM274 reported that a civilian threw cigarettes into the warehouse in Kravica for them. That's P3098, page 19. And that they were brought water. That's the same exhibit, page 21. RM 274 likewise described that the guards were consistently kind towards the detainees in the beginning. Again, referencing cigarettes and water being provided later. That's at page 24 of that same document. He estimates this process continued this way 1.5 to 2 hours. Moving on to the next paragraph. RM 274 reported that things only changed after an incident that made the guards angry. He stated that shooting was heard from outside the warehouse, and 2 angry guards came in and said they wanted to shoot at the detainees, but a 3rd guard stopped them, saying, quote, "These people are not to blame for anything," end quote. That is at page 21 of P-3098. This is the trigger incident where shooting went on for half an hour, for which RM 274 claims the guards were suddenly angry and were shooting into the forest with a praga, complaining that they had allowed Muslims to go peacefully and that Muslims were now attacking them. This is P-3098, page 22 and 24.
Excuse me, Your Honors. Sorry to interrupt, Mr. Ivatic. Your Honors, it's our understanding that P-3098 is an exhibit that's under seal, and my case manager is checking, but we don't think that there is a non-confidential version of that exhibit.
And I don't think I've said anything that would lead to anyone being able to determine the identity of that witness. May I proceed?
Madam Prosecution, have you finished your investigation?
Yes, Your Honor, we've just looked into it, and we don't think that there's a serious witness protection issue here.
Specifically?
We do not think that there's a serious witness protection issue here. Thank you.
Okay, thank you. You may proceed, Mr. Ivatic.
Thank you. RM 274 recalls a wounded guard was brought in, and it was only after that incident that the guards came in acting frightened and in a panic, started shooting at detainees in the warehouse. And that is at pages 27 to 28 of his statement. I will skip ahead and summarize the next page, so bear with me, translators and court reporter, I will speak slowly. So the burned hands incident, what was it? Several witnesses from the prosecution and defense, RM 374, witness Pepic, RM 268, witness Jovcic, and one more, I believe. No, yeah, Jovcic is the last one. Talk about an incident at Kravica where one of the detainees grabbed a rifle from the MUP guards, shooting at the guards, killing one of the guards, and wounding one of the other guards. So there was a legitimate exchange of fire. After that, spontaneously, the MUP personnel there acted out of revenge and committed a crime that was not pre-ordered, not known until after the fact. And now I'll skip to the next page, and the critical part witness Jovcic, the driver of the MUP commander, testified that after this incident, the MUP commander Borovchinin reported to the civilian authorities and asked the civilian leader Deronic to do something about the situation. And that's at transcript page 1143 to 11424 and D976, paragraph 34. Kravica is a horrible event, and that's where the killings started. But it transpired not due to any orders from Mr. Mladić, who was already gone at that time. And as the prosecution's expert, Renown Tunins, mentioned, with the MUP that committed crime, once the civilian leadership has been informed, they are responsible for discipline. As to the post factum and the inability of Mr. Mladić to take action against perpetrators, we have set that forth in our brief, and we stand on that. So in the end, as to Srebrenica, the prosecution wants to run from its own prosecutor, its own investigator, its own evidence to try to support unaired judgment. They want to run mostly from the statements of Mr. Nielsen in the video showing how Mr. Mladić was convicted on implications. Surely justice and genocide require evidence that a prosecutor cannot and should not run from. The defense does not run from the fact that crimes by rogue revenge seekers, aided by Momir Nikolic and his lot, committed crimes, then hid these crimes with legitimate casualties. But again, no link to Mr. Mladić. Mr. Mladić is not a villain. He was someone who at all times was trying to help the UN do the job it couldn't do in Srebrenica at a humanitarian level. Next, I would move to the OJCE. At the transcript from yesterday, at page 95, the prosecutor said, in one of the most notorious camp massacres, VRS soldiers gassed and then slaughtered 200 detainees with a single machine gun while the guards sang songs. And I'd refer you to paragraph 1121 of the trial judgment. If you look at that part of the judgment, and if you look at the evidence, you'll see that this refers to C.15.3 Kara term, which, per the evidence, was established by the Prijedor crisis staff, was managed by the local police, and under their responsibility. I tell you to look at P2900, P480, and D1041. It was requested on 24 July 1992 that the VRS take over management and operation of Karaterm from the civilian police. And that is at D111. However, that didn't happen. In fact, the VRS reported any suspicious crimes to the appropriate officials, and cases were opened against officers Zoran Žigić, Damir Doshin, among others. And that is at D930, paragraph 24. These two people were later tried by this tribunal as high-level commanders of Karaterm. As to this infamous killing that the prosecutor cited to, the Room 3 massacre, it is clear that the police were in charge of that facility. And in fact, Durlacha, the police chief, noted in his report that the army refused to provide security at these centers. That's in D1111, page 1. So this killing that the prosecutor relied upon to point to my client, Mr. Mladić, here is the only information that came to him, and it's P161, and it's talking about this police detention center. Quote, the prisoners at the collection center in Prijedor, located in the Karaterm factory, attempted a mass escape on the night of the 24th. The attempt was thwarted and about 50 prisoners were killed in the process. So the knowledge, the intent of this massacre, as the prosecutor called it, was not ever made known to Mr. Mladić, nor could he do anything about it since it was the MOOP. As to overarching JCE, I would also like to just say, as we've said in our brief, at paragraph 26 of our appeal brief, we state the legal principle that the trial chamber's judgment must take the evidence as a whole, whereas all elements of a charge must be made out to substantiate the charge. You cannot stand back and hope one element fills a gap in the other. The actus reus cannot supplement gaps in the mens rea because they both require different evidence to prove their independent requirements. And on this point, I would direct you to the ICTR case. I will not attempt to pronounce the name, but it's known as the Military II case, the appeals judgment, and it's from 2014. A trial chamber is required to provide clear, reasoned findings of fact as to each element of the crime charge. The trial chamber's failure to provide a reasoned opinion amounts to an error of law which allows the appeals chamber to consider the relevant evidence and factual findings in order to determine whether a reasonable trier of fact could have found beyond reasonable doubt that the requisite actus reus and mens rea were established in relation to enzuwun e muyes and saga hutus liability for ordering under Article 6.1 of the statute. I will not rehash what we have in our brief, but this is what we're asking for the appeals chamber to do as to the overarching JCE. And with that, I grant the floor to my colleague, Ms. Bagot, to give the remainder of our submissions. Thank you.
Madam Presiding Judge, Your Honours, I'll start with ground one. The concession that the challenged incidents that have been identified as unscheduled incidents should be withdrawn was made because it was quite proper to do so. Therefore, my learned friend is correct that orally those have been withdrawn from the appeals chamber's consideration. The appellant submits, however, that the others stand for the reasons set out in the appellant's appeal brief at paragraph 48 and for the reasons indicated by my oral submissions yesterday. Notice. My learned friend for the prosecution responds by referring to the inclusive language used in the indictment. The response goes no further than the written response, and in fact rehearses the arguments set out therein. As the example I used yesterday, which went back to the basics of an adversarial criminal trial, the inclusive language in an indictment does not enable the trial chamber to convict on every accusation it heard. My learned friend for the prosecution indicated that the sheer size of these trials removed the need for a fixed indictment in the traditional sense and allowed some flexibility. As a matter of fairness, this cannot be interpreted as meaning that a trial chamber in an adversarial trial can convict on any and every accusation it hears evidence on. To take this view would be to invite the trial chamber into the arena of the parties and exercise an investigatory function. I ask this chamber rhetorically, how is it fair to Mr. Mladić that the trial chamber took the view that all the evidence it heard was some sort of buffet from which it was entitled to stack its plate as high as it wanted? The indictment and notice requirements are there for a reason. They guard against this. The prosecution have failed to explain how the defence was put on notice of these unnamed, unscheduled incidents being anything other than mere accusations. If the chamber considers the 65-ter witness list, considers the pre-trial brief, and considers the witness statements, it is clear that the accusations form part of the narrative and nothing more. The appellant submits this is insufficient notice. Objection. The quote from the defence motion for reconsideration has been relied on to suggest that the defence's failure to object to the admission of evidence then now means on appeal that prejudice cannot be alleged. The Rule 73 bis D decision adopted a proposal on the reduction of the indictment. That decision was to reduce the number of scheduled incidents. The decision explicitly stated that evidence of the incidents that had been removed could be led. However, quote, the chamber notes that the accused cannot be convicted with respect to the crimes which have been removed pursuant to Rule 73 bis D of the rules, close quote, paragraph 12. Therefore, the quote relied on by my learned friend must be placed in its proper context. It was a response to the admission of evidence that the trial chamber said it could not and would not convict on, as the incidents had been removed from the indictment. The question posed on the basis of the Bagasora decision was, is there a reasonable explanation for the failure to object at the material time and as soon as possible thereafter? The answer is yes in this case. The defence were not put on notice that every accusation on the record could be used against Mr. Mladić. The evidence may be admissible as a matter of law, but that is a separate matter. Simply because accusations enter into the record does not mean that they can be transformed into unscheduled incidents by the trial chamber of its own volition. For this reason, the appellant submits that the defence did not have knowledge that the trial chamber could enter convictions on these unnamed, unscheduled incidents. Prejudice. The prosecution argues that there are a small number of incidents complained of, and therefore it would not make a difference to the overall convictions. It is argued that there is no prejudice. Upholding any findings on an erroneous legal basis is unfair and harmful. It is prejudicial. It is prejudicial because Mr. Mladić was found criminally responsible for these incidents. Be it 1 or 100, to hold an accused guilty of anything in breach of fundamental due process norms is prejudicial. To conclude the reply on ground 1, the appellant refers the chamber to the appeal brief at paragraphs 41 to 60 and the reply at paragraphs 8 to 15. The appellant invites the chamber to reverse the findings on the crimes identified. Ground 2, proximate subordinates. The prosecution assert that the appellant fails to show cogent reasons, but accepts that there is a divergence in the way in which trial chambers exercise their discretion. The fact that there is a division between trial chambers that follow the Camara approach and consider the only facts that go to the actions, conduct, or mental state of the accused should not be subject to judicial notice, and then those that consider that in situations in which it would be easy to infer that an accused knew or should have known about the physical perpetrator's actions based on the prosecution's case, then it would be unfair to take judicial notice of such facts. Citing the Karadzic appeals judgment only serves to highlight this fragmentation. How chambers exercise their discretion must have a degree of consistency. It should not be a judicial lottery as to whether or not judicial notice of facts relating to the perpetrator's actions that the prosecution say are strongly linked to an accused are taken judicial notice of. This compounds the need for the issue to be revisited. Contribution of Mr. Mladić proved through adjudicated facts. The prosecution alleged that the appellant has not shown the, quote, short step, unquote, was used by the trial chamber to establish contribution or mens rea. The appellant refers the chamber back to the example provided yesterday of the incident of the 23rd of July 1995 at paragraph 2210 of the judgment. The trial chamber found that Mr. Mladić used the SRK as his subordinates under his effective command and control to contribute to the JCEs, and that the crimes were committed under his orders. That's set out in the findings in section 9.3.10 of the judgment. This demonstrates the short step the trial chamber took. The example of the 23rd of July 1995 shows that the prosecution did not have to prove the identity of the perpetrator, which was a core element of its case on responsibility. The trial chamber relied on an adjudicated fact. The appellant submits that the further examples in paragraphs 107 and 108 of the appeal brief demonstrate that it is shown that the trial chamber established Mr. Mladić's contribution and or mens rea through the use of adjudicated facts in the manner argued in the appeal brief. Approach to rebuttal evidence. My learned friend repeats the arguments from the written response. As they have been addressed in the reply at paragraphs 22 to 30, I refer the Chamber to these. The examples that were provided from the judgment by my learned friend do not undermine the appellant's reply in this regard. Adjudicated facts do not require corroboration. The prosecution asserts that this is the case. The prosecution argues that it, quote, does not matter, close quote, that the prosecution evidence was insufficient to prove the same point. The appellant recalls paragraphs 31 and 32 to the reply for this. The use of adjudicated facts does not alleviate the prosecution of their burden of proof. If their own evidence cannot establish the facts it seeks to rely on to prove its case, adjudicated facts should not be used as a substitute. Judicial economy cannot be at the expense of the basic principles of a criminal trial. The prosecution must prove its case beyond reasonable doubt. Adjudicated fact 1476. The appellant's written reply addresses my learned friend's submissions on this at paragraphs 33 to 37. As the oral submissions made do not go any further than those set out in the written response, I do not propose to rehearse or reply in this regard. Illustrative examples. My learned friend for the prosecution yesterday stated that the provision of illustrative examples is insufficient to trigger a review of the entire judgment. The appellant submits that an error in the trial chamber's methodology has been shown in relation to adjudicated facts. Flowing from this, the appellant has provided examples where this erroneous methodology was applied and the results therein. The appellant has not just pointed to one or two. It has pointed to examples of this in each schedule of the incidents annexed to the indictment and in the unscheduled incidents. The Chamber is directed not only to paragraphs 107 and 108, but also in the specific grounds on the counts of the indictment. These are highlighted and reviewed to show how the trial chamber erred with worked examples. To conclude on ground 2, the appellant invites the chamber to first articulate the correct legal standard, second, review the relevant findings of fact, and finally, reverse the trial chamber's findings that Mr. Mladić was responsible for the incidents infected by this error. Ground 4. My learned friend for the prosecution yesterday Madam Presiding Judge, I've just had an indication that we're at a convenient point for a break and perhaps we should take it now.
Very well. We'll take a break for 40 minutes and we will return at 15:50.
All rise. We will leave.